Good afternoon. Good afternoon, and thank you for joining us for this roundtable on sexual violence and the death penalty. My name is Neetika Vishwanath. I am with Project 39A at National Law University, Delhi, in New Delhi, India. Project 39A provides pro bono legal representation to death row prisoners in India, and we also do a lot of empirical and doctrinal research on the death penalty. And we also work on other criminal justice issues, including mental health and criminal justice, legal aid, torture, and forensics. The conversation today is specifically about sexual violence and the death penalty, so I want to set some context before I introduce my guest and tell all of you what she's going to be talking about. So at least 7 countries around the world have death penalty for rape, and many want to reintroduce it. For instance, my own country, India, far from the global trend of moving away from the death penalty, in the last decade, we've seen a constant legislative expansion of the death penalty for sexual offenses. And very recently, in 2019, we had the death penalty being introduced for non-homicidal child rape. Before that, we had death penalty for repeat sexual offenders. And as of today, 28 persons have been sentenced to death in 22 cases for non-homicidal child rape. There was one case involving death penalty for repeat sexual offending, which was later commuted. And many more are sentenced to death every year in India for rape and murder of both women and children. The conversation today, after Judge Grev shares her intervention, is mainly going to be focusing on people who work with survivors of sexual violence or who work on the issue in their countries, in their region. And my speakers are from India, Pakistan, Bangladesh, Tunisia, Senegal, and Democratic Republic of Congo. And I am going to give a little more context about these countries a little later and what the situation is. But as of now, I just want to set the context by saying that what we've seen in these countries where there's been introduction of death penalty for sexual violence or a conversation about reintroduction of death penalty for these offenses is that sexual offenders, first of all, I think there's been a political use of sexual offenses in the name of victims to move towards more and more harsher punishments. And what we also see is pitting the victims against the accused, completely losing sight of the fact that often both their claims lie against the state, and the state sort of takes a backseat and allows vengeance to play out and and really capitalize on the public opinion. And also that a lot of these cases are very minute category of how sexual violence actually plays out. These are cases that involve stranger brutal rape, which perhaps form one aspect of what the sexual violence terrain looks like, and we'll talk about this more later. But to my speaker, and I'll introduce her once I'm just done adding one more thing, that what we see in these countries is that some kind of demonization of sexual offenders, that these are demons, these are not humans, these are people who don't deserve any rights at all. And in India, we've seen bar associations refusing to represent sexual offenders, leave alone providing them quality legal representation or making submissions at the sentencing stage. And I want to sort of talk to Judge Grev about this and understand how should we respond to this idea that some people are cannot be redeemed, and some people do not deserve rights. Before I do that, I just want to introduce you. Judge Grev is a commissioner at the International Commission Against the Death Penalty. She's a judge, and she's the vice president of Gulating High Court for Western Norway. And she has more than 30 years of experience in international law and is committed to protection and promotion of human rights. I hand it over to you.
Thank you very much. I might add a little bit as to my background. I did work for the Security Council on investigating war crimes in former Yugoslavia. And among them, there were many, many very bad sexual offenses. Offenses against women, offenses against men. It's important to remember that it's also possible to rape and castrate, not the least, men. And those who are castrated may not survive, so we don't hear so much about them. But it is an issue for humankind. It's not only an issue for women. And before we start to speak about also the rapist or the offender, I would like to emphasize that one of my learned colleagues, she's a philosopher, she's always emphasizing that no one can be degraded by someone else. They can be treated very brutally, very badly, in the most insane manner, but they are not degraded by being maltreated or abused. It's the one who are abusing them who is degrading him or herself. That has to be done by the person themselves. And I think the fact that was in your introduction is very important, that it's more countries these days who want to say, yeah, we have to take tough action when it comes to sexual offenses. But this is not exactly what they are doing by reintroducing the death penalty. In some sense, they are actually giving up on their main duty, which is to uphold the rule of law. And let's go back a little bit. In each and every one of us, there is two persons, two personalities. I'm me, but vis-a-vis you, I'm the other one. And to be fully human, I really have to appreciate that I must function as me, and I must function as the other one. And this, to a high degree, is a question of trying to enhance human dignity, upgrade the life of everyone, and to educate people. And it's also stated that actually the only one inborn right to every human being is freedom. A freedom where your freedom can be combined with mine. And each and every one of you has a freedom, and mine stops when it meets yours. All of this is educating people. Of course, it's for the state to provide security, human flourishing, and social cohesion. And of course, it's not enough for a country simply to punish offenders. It's too late for every victim. The victim should be protected against being subjected to sexual violence. And that has to do with education as well. It has to do with making just social systems. It has to do with making a climate conducive to everyone to lead decent and good lives. And if they so can, we may have far less rape. If a rape takes place, I use that for all kinds of sexual violence, just to have shorthand. But if a crime has been committed, we frequently see two things: that society will turn its back to both of them, both to the victim and to the offender. The victim, in the sense that if the victim is underprivileged, poor, from a marginal group, maybe no one cares at all. They won't see justice in their case. And on the other hand, if the victim has support from a community, family, whoever, we may see that the society turns it back to the perpetrator. There will be a big pressure on the prosecution to find the victim, to find the one who is responsible. And let's start with a situation where they don't know exactly who is responsible. This kind of pressure will easily lead to the fact that one just finds someone, hang someone, and then you've settled the problem, regardless of that being the guilty person. That's not justice. That's not serving the victims. That's not improving the conditions for possible victims in general. And it's definitely not right vis-à-vis the perpetrator or the one who is being accused of perpetration. And it also means that this is a subject that may easily be linked to corruption. If you need to find someone, you think you can perhaps find someone, and if the offender is of some standing, that person could perhaps be able to bribe his or her way out of it. Whereas it's the marginalized people who are hanged, who are prosecuted, who are taken in these cases. And because it takes, frequently it's quick justice, it also means that the possibility of making mistakes is very high. It's so many judges who are fearful, of course, of making mistakes, but also sensitive to public pressure, so that they may rather pass a harsh sentence to show that they've done what was needed. But let's then focus on a situation where we know for sure that we have the perpetrator. We are quite sure that this is the person who needs to be punished. There is no information to indicate that the fact that rapists, for instance, are hanged, that will reduce the number of such crimes. The key issue in all of this is whether or not to tolerate impunity. If a serious crime can be made with impunity, that is extremely destructive. But then we should make sure that no impunity, and for the victim, it's very important that the truth is being told. Having someone brought to justice, taking the time that's needed, punished, maybe with a very long sentence, that is likely to serve justice, the victim, and society much more. But that demands that also society will invest in proper justice. There are no demons. There are only human beings. Thank you.
Thank you so much, Judge Greve. Thank you for that very valuable intervention, and the audience will have an opportunity to address questions to Judge Greve when we have Q&A towards the last part of the session. Please join me in inviting my amazing speakers for the conversation today. I have 6 speakers from 6 countries, and I'd just like to quickly introduce them before I set out a little more context and start having this conversation. Bharti Ali on my right is from India, and she's one of the co-founders and executive director of HUC, Center for Child Rights. MD Ashrafuzzaman is the program coordinator of the Asian Legal Resource Center and the head of the Bangladesh desk at the Asian Human Rights Commission. He's one of the co-authors of Anti-Death Penalty Asia Network's report, A Deadly Distraction, Why the Death Penalty is Not the Answer to Rape in South Asia. Charlene Yangazo is from the Democratic Republic of Congo, and she's the president of the organization, and pardon my French, Autre Nouve Asbel. She's also defended and socially assisted a woman sentenced to death for whom she obtained a release. Aissatou Kante is from Senegal, and she's the president of the Commission on Children's Rights with the Association of Senegalese Women Lawyers. Valerie Khan from Pakistan is a gender justice and child protection specialist and private consultant. She previously was the chairperson of the Acid Survivors Foundation and the executive director of Group Development Pakistan. And my final panelist, Shokri Latif from Tunisia, is the president of the Tunisian Coalition Against the Death Penalty. Thank you so much for joining me for this conversation today. Before I start, I just want to lay out some context about the 6 countries that we are talking about today. 3 of these countries, India, Pakistan, and Bangladesh, have the death penalty in place for rape, and in that sense, it's wider in Pakistan and Bangladesh because there is no age limit when it comes to death penalty for rape. In India, we have death penalty for repeat sexual offenses, for non-homicidal child rape, and some states have also been considering and passed bills to introduce death penalty for rape of adult women. So we are constantly seeing an expansion, and I think we're just one more case away from that being the law across the country. Democratic Republic of Congo is a de facto abolitionist state. It carried out its last death sentence in 2003. However, 41 individuals still received death sentences in 2018. Punishment for rape is penal servitude, ranging from 5 to 20 years. And there is, formally, there is the death sentence if rape leads to murder, it leads to the victim's death. Tunisia has maximum of 20 years or death if there is use of weapon or if it involves a child victim under the age of 10 years. However, there's been a moratorium on the death penalty, but there have been, in response to recent rapes and murders, a conversation on reintroducing the death penalty for sexual offenses. What I want to sort of, and Senegal abolished the death penalty in 2004, so that's one country that has gotten rid of the death penalty. And in the conversation today, what I want us to sort of really understand is, does the death penalty for sexual violence correspond with the needs of the survivors and victims? Because often what we see is that governments move more and more towards harsher punishments in the name of the victims, and that's what we're trying to sort of unpack. And I do want to underscore, before I ask my first question, is that sexual violence is a broad terrain, and there are different forms of sexual violence. There is sexual violence within the private sphere, within marriage. There's sexual violence outside the public sphere, in public spaces, stranger violence, which is often what we hear about. There's sexual violence against sex workers. And I also want to sort of clarify that sexual violence may not always just be a tool of patriarchal oppression. For instance, in India, you also see it play out in the communal context. You also see it as an assertion of caste power. So it is a very heterogeneous offense, and there are multiple subcategories of this offense. And often what we hear and what is thought of as sexual violence in the public imagination is very much stranger, brutal violence. And we are going to sort of talk about that and see what is the actual reality of sexual violence in the countries that we are talking about today, and how does the death penalty correspond to that. So my first question is, Valerie, to you, and I'm going to be asking you this question on behalf of South Asia. I don't want to ask that to Zaman and Bharti because, I mean, culturally, sexual violence and the way it plays out is quite similar. So I will just reserve the question to you from South Asia. But before that, I want to say one more thing, that I'm entering this conversation with a proviso that I think law has a very limited role to play when we talk about sexual violence. It's not a problem that law is well equipped. So I want to enter this conversation with that acknowledgement that let's not think that we are going to find magical answers to the problem of sexual violence. law has a very limited role to play, and we are just trying to see how can that limited role be more effective, and why the death penalty is not the role that the law should play. So that's what the focus of the conversation is going to be today. So Valerie, I sort of want to understand how you would characterize the problem of sexual violence in Pakistan, and also can you tell us a little bit about its pervasiveness, its various forms, and how is it seen and understood in the Pakistani culture?
All right. So it's a rampant issue, which is largely underreported in the context of Pakistan. And that is an issue that has actually, however, although it's underreported, it's increasingly reported. And usually, more than often, in a very sensational manner. And with very little regards of the best interest of the victim, or the best interest of the accused when we're talking about juvenile accused. It's also a practice which is, on one hand, extremely condemned, and with a public outcry which is increasingly demanding that the state takes action to stop it. But it is also nourished or fed by harmful traditional practices, such as child marriage or some forms of commercial of sexual exploitation of children, such as bachabazi, for example. And it's also linked to very strong taboos, and it's ingrained and it takes place within a context where you have a very high level of socio-economic inequalities, high level of gender discriminations, a very, very limited lack of, I cannot use the term sexual education, but let's call it life skills-based education, and I mean extremely strong taboos. So on one hand, lawmakers, justice actors, and the general public really wants this to stop. But on the other hand, the reflective process to analyze where this is coming from and how, other than the law and the death penalty, what are the other alternatives to do so, is not necessarily reaching the mainstream narrative. However, I would say it's a bit of a dichotomic dynamic, because in the same time, in parallel to this very, I would say, challenging environment to acknowledge sexual violence and counter it, we are currently in Pakistan facing an unprecedented momentum and action, which is highly led by the judiciary and to some extent by the law departments, including the Federal Ministry of Law and Justice, to actually take action in what is conceived as a very much victim-centric manner. So the question here is, and especially when we talk about death penalty, does that victim-centric manner is careful enough to ensure that the rights of the accused are not being violated? There has been historical steps such as establishment of child court or gender-based violence courts, national-wise capacity building program for justice actors, trying to increase the women's representation in the justice sector, and also trying to conduct mass media awareness campaigns that are state-led. So I would say huge difficulties, but a lot of hope and an increasing demand for, I think, an evidence-based and scientific-based solution, framework of solution, which in any case is going to be intergenerational, is going to take time, and it's far more understanding, awareness, and resource allocation.
Thank you, Valerie. Charlene, I have the same question for you for Democratic Republic of Congo. And specifically, I'd appreciate it if you could talk a little bit about the sexual violence from the armed forces in Congo. Thank you.
Merci beaucoup, Nitika.
Thank you very much, Nika. So when it comes to the Democratic Republic of Congo, it's for some decades that my country has seen sexual violence anchored in its culture. So we've seen that sexual violence is anchored in the Congolese society, and in particular in those zones in the east of the country, as you know, that are zones that have been suffering different wars and civil wars. So these zones are used, or in these zones, sexual violence is used as a weapon in this war. Dr. Mukenge has even once said that rape is perpetrated in these zones, not the sexual desire of men or whatever sexual desire, but in the willingness of those perpetrators to destroy the victim physically and also morally. And we also know that there are members of the armed forces that commit sexual crimes, and others, and they're protected because of using this sexual violence as a crime. So this applies in particular to the zones where there's armed conflict. So sexual violence also exists in those parts of the country where we have peace. But in those zones, we consider sexual violence as a crime that may occur. It's not used as a weapon in those parts of the country. So we may even say that Democratic Republic of Congo is the capital of rape. So when we talk about societal life, sometimes the victims themselves don't consider themselves to be victims. They don't recognize that they're victims. They don't see themselves like that. But there is also something disquieting here in the interpretation. In our legislation, in 2006, the legislator in Congo has adopted a law which is practically instituting capital or the death penalty. Since 2006, the parliament has adopted a law that has increased punishment from 5 to 15 years. And since this repression has been reinforced, we've seen that the number of victims has not diminished. In the contrary, the number is increasing compared with the times where only 5 years of imprisonment were given to perpetrators of sexual crimes. So it has not stopped the level or the intensity of number of sexual crimes. So it's the dependence of the victims, the fear, the sexual violence at home, domestic violence, all of these different forms of sexual violence have still continued to exist. And here I would like to read, because there are different forms. We've seen, for example, with this law, that the legislator has increased the punishment, number of years of imprisonment. So domestic violence, forced marriage, attack on the pudor of a woman, harassment, sexual harassment, mutilation in a sexual sense, forced pregnancy and pornography, as well as some others. So different forms of sexual violence that are covered by this law adopted by the legislator in Congo. So this is important when we look at the perception of the Congolese society. To be a victim, this is something that is very embarrassing. It's a situation of dishonor. It is so dishonoring to be a woman woman that has been a victim, has been subject to sexual violence, that sometimes these female victims or children victims prefer to keep silence about it and not speak out. If the women don't speak out, they don't have the means to report the perpetrators or even go to take medical assistance or go to court. Sometimes they are afraid of repression, of problems related from reporting the perpetrator. Even entire families are afraid of that. So they prefer to find an amiable arrangement with the perpetrator. So these are the families that look for an amiable arrangement, like a sum of money and compensation money for the crime that has been committed against them, or for a marriage with the victim that has been subject to rape. So in the society in Congo, we also see that sexual violence is used as a money-making machine to gain money. So children, girls are used for making money. Like a pitfall for particularly rich men to be seduced by these girls, and they are accused of rape, and those potentially rich persons would then enter into an arrangement in order to pay compensation to the family of the victim, especially in those zones and parts of the country where life is peaceful. And this is seen as a sort of crime then.
Thank you, thank you. A very similar experience in India, and I think Bharti will talk more about it, about how there is a certain kind of stigma as a sexual violence survivor. And Bharti, I'll come to you a little later with my question. And I think what is also interesting from Charlene's comment is to understand that there's a lot of difference between sexual violence as we understand it and what is being interpreted as sexual violence within the current legal discourse. So for instance, the use of these cases to negotiate for money, or Bharti will reflect on how you see that rape is used to criminalize love, where you see a lot of consensual couples eloping to get married because their families are against it, and then the family of the woman uses rape as a tool to criminalize, to get their daughter's lover behind the bars. So, I mean, there's a difference between sexual violence as we understand it and how it's being interpreted in the current legal discourse. And I think it's very important to look at the empirical evidence to see what's happening before we sort of decide how we want to act on it. My next question is for you, Chokre, and it's the same question in the Tunisian context, but I want you to tell us a little bit more about the recent repeal of marry or rapist laws in Tunisia and how that came to be and what is the situation right now. Thank you.
Merci. The
problem of sexual violence in Tunisia is a major problem that has an impact on the society in all its dimensions. But we could a priori say that the coming up of violence, where mainly women are victims, is a paradox of history for a country that is considered to be avant-gardistic, especially when it comes to women's rights. And when we look at other countries in the Arab world, so the Code of the Prison Statute that has abolished forced marriage and polygamy and repudiation has been adopted in 1956. Voting rights for women, the right to abort has been adopted several years after. But the problem of violence is still on the agenda today. In 2019, the official statistics said that there were about 800 cases per day, of 800 cases of rape per day. So that means 2 per day. 65% of the victims were children, 80% were girls. And then in 2021, nearly 70,000 complaints have been received. The numbers went up from 87% in 2020 to 96%. It's women that are victims of verbal, physical violence in the public space and at the workplace, but it's also in the context of the family, where 72% of all the cases of violence have been reported. It is always, in this case, the wife or the husband that is the perpetrator in 74% of the cases. So what is really alarming is that this violence also leads to a large number of feminicides perpetrated by also the security forces. For example, a case 2 weeks ago where a woman was burned alive in front of her children, and a policeman has killed his wife by shooting it. So we see that the different age groups that are subject to violence are 30 to 40-year-olds, 32%, 41 to 50-year-old, 30%, but all women that are exposed to violence, most of them have no work and are therefore most vulnerable. In our culture in Tunisia, rape and sexual violence have for a long time been a taboo. So dissimulation and rejection is always prevailing. But after the revolution, which took place in 2011, this phenomenon has become public because liberated media, no censorship anymore, have led to public discussions about the problem, and democratic structures have taken over. But there are also other determinants that have changed the situation. The propagation and massive diffusion of Islamist ideology that have been in power since 2012. So they want to establish the status quo and the patriarchal order that sees women as inferior and that allows for an appropriation of their bodies. Other determinants have come into play, like poverty and economic vulnerability of female victims, or the ignorance regarding their rights stipulated in law, or impunity regarding the perpetrators. In view of that situation, the feminist and democratic movement that is very progressive in Tunisia, including all its components, wants to defend this acquis of Tunisian women and to fight against all sorts of and all forms of violence that they're subjected to, in order to abolish this phenomenon and put an end to the silence around the problem of feminicides.
Thank you. Thank you. So I think what we see here is a lot of similarity about how deeply embedded sexual violence is in different cultures. And we also see some things that are unique to that specific culture. And I now want to sort of move to the conversation about, okay, for victims who do, for survivors who do access the criminal justice system, what are the challenges, what are the hurdles, and what happens when you introduce the death penalty to this context? And I want to ask you, Bharti, specifically in the context of your work with child survivors and their families in India, what do you see as the challenges and how relevant are harsher sentences, including the death penalty, in addressing these barriers?
Thank you, Nitika. I think just to add one more layer to the various forms of sexual violence that everyone here has added. When we look at children, it's not just sexual violence against girls, it's sexual violence against boys as well, and also transgender children. And all are at different pedestals, you know, in the sense, the way the society looks at it and treats it, and also probably the way those responsible for delivering justice look at it and treat these different layers. Having said that, therefore, the question of access to justice also varies. The response to sexual violence against girls, particularly where it's penetrative sexual assault, is, and we've seen it in the law, as you mentioned, Nitika, that it has come in the form of extreme sentences like death penalty, and also minimum mandatory sentences. The response to a similar penetrative sexual assault against a boy would probably be different from the courts and the court system. So that's how it changes, and therefore they are at different pedestals. Having said that, I'll say that there are several issues when it comes to access to justice. Do we have the right courts that are exclusively dealing with sexual violence? Because we often hear from judges, trial court judges, that I was at a murder trial and now you expect me to switch suddenly to deal with a child. I can't do that. So do we have those exclusive special courts? Do we have special public prosecutors who are trained to deal with children and work with children? That's one of the biggest problems that we face and challenges. We have been representing children in different trial courts, and our experience with about 457 cases at the moment tells us that, they don't find appropriate legal assistance and free legal aid, and therefore other pro bono services have to stand up and come forward to represent them. B, there is a huge delay in the trials. The law in India says that the testimony of the child should be recorded within 30 days from the court taking cognizance, but that seldom happens. So only 1% of the 457 cases is where they could complete the testimony within 1 month. Similarly, there is a huge pendency. About 92% cases are pending in the trial courts. And every time a child or even a woman, an adult, has to appear in the court, they should be getting some kind of travel reimbursement. I mean, I'm talking about these small things because this is what access to justice is about. And we cannot move away from these small but very important things. So that, do they get travel reimbursement? Do they get meals? Because they have to be there in the court from morning to evening. You never know when your turn comes. Those are important questions, and we need to start asking those questions. Investigative lapses. Are we holding anyone accountable for the lapses in investigation? Compensation. There are victim compensation schemes in many parts of the world, including India, but is that compensation reaching them? Often they don't have bank accounts. They don't have identity documents to open a bank account. And so I'm therefore pointing out each of these details. And in that situation, then, to be asking for death penalty sounds awful. I mean, it just makes no sense. Many other things. I mean, I can just go on. There's aggressive questioning to children that continues. There's direct questioning. We're supposed to have vulnerable witness deposition rooms so that the child and the accused, they don't come in contact. But in a country like India with over 650 districts, it's very difficult to have such a setup. But at least some sensitivity could work. I mean, I've seen cases where a judge has used everything available in the courtroom to create a screen between the child and the accused, but that's one judge. And so therefore, there's need for training of judges as well. So there are a range of these issues, and I honestly can't see how death penalty can actually deal with issues of access to justice, which require primary attention.
Thanks, Bharti. And I think what you spoke about, the investigative lapses, right? I think they harm both the victims and survivors as well as people who are accused of these crimes, because in so many cases that Project 39A does, where we've gotten acquittal at the Supreme Court of people who've served time on death row, has very much been because of investigative lapses. And we've seen that play out in 2019 in India, where 4 people were picked up for rape and murder of an adult woman, and they were taken to this site, which was the site of the crime supposedly, and the police's version is that they tried to escape. I don't know how, because the police had guns and there were a lot of them, and these were 4 accused persons, and basically they were shot on the spot. And these policemen were garlanded, and this quick idea of justice was celebrated. So investigative lapses are concerns that play out negatively for both the victims as well as the accused persons, because either you are not doing the investigation properly and so it's leading to an acquittal, or you're picking up the wrong person, or you are botching up the entire evidence. So investigative lapses becomes a concern that plays out at both sides. And just a quick follow-up, Bharti, I know this was not planned, on quick trials, because I know that the law says that the trials have to be speedy, but the flip side of that has been extremely short trials in India, sometimes trials in very serious cases, capital trials, which last for just a week, and you have the person being sentenced to death. And it's not speedy justice, it's basically ineffective legal representation and not proper adjudication. So these cases are overturned at the High Court and the Supreme Court. So I mean, what you get in the name of speedy justice is these quick trials, and then ultimately these lead to acquittals, or accused persons are serving time on death row for many, many years till they get acquitted. And it neither works well for victims nor for people who've been accused of these crimes. So if you want to talk quickly about that.
Yeah, very well said, because it doesn't actually work well for victims either, and especially when victims are children. They need their own time to open up and to be ready for the testimony, and sometimes they need longer than that 1 month. So how do we fix the period of 1 month for recording testimony, the period of 1 year for completing trial? There is really no policy that one sees, and not much research has gone into what should be the policy, and how do you arrive at that period of completion of trials. So that's a problem. And then the other problem is that a lot of the offenders, especially in cases of children, are known offenders. The National Crime Records Bureau of India has been telling us that about 96 to 97% cases are where the offenders are known to children, and that makes it even tougher for them to really open up and testify. So, I mean, all I can say is that the pressure on the child is far too much when the offender is known, and then you want to complete trials in a certain time. That's not justice, but injustice in many ways.
Thanks, Bharti. And I just want to reiterate that empirical evidence that we see from India and other countries, and our latest statistics, crime statistics, state that 96% of perpetrators in child sexual abuse cases are people known to the victims, so known to the perpetrators. So when you introduce death penalty to that context, instead of this theoretical imagination that will deter crimes, it actually deters reporting. And underreporting is anyway a very big concern for all the reasons that Charlene mentioned, the stigma and just the hassle of accessing a system that is so broken and hostile to the victims. My next question is to you, Aisatu, and since Bharti spoke specifically about child victims, I wanted you to reflect on your own context and what have been the hurdles to access justice for adult victims or survivors of sexual violence in Senegal, and how relevant are harsher sentences in addressing these barriers. Thank you.
Merci beaucoup.
Thank you very much. Please allow me to correct a bit. I'm a magistrate and member of the Association of Legal Women, Legal Experts. It's a big movement that includes all female lawyers, notaries, judges, so the legal profession, also police commissioners, and I'm a member of this association where I am in charge of the section defending children's rights. Regarding the question, it's important to say, well, I'm a judge, magistrate, and my colleagues have the tendency of calling me a feminist. And when I look at the decisions in the scope of rape, I pass sentences regarding perpetrators of rape. And I'm always told that I was on the side of women, but it's a violation. And like any other type of violation of law, the perpetrators could be women, men, or even children. Rape, that's a violation of law. It's just a technical term. What is different with the death penalty, which is a term of international law. Instrumentalize rape up to a point where we give life to a person. I think this is, take the life of a person is inadmissible, because rape is degrading. It is an attack to the dignity of a woman, and rape is a trauma-like event. You can destroy life of a woman, but whatever the intensity is, whatever the level of bad is, it cannot lead to the capital punishment, to a death sentence. Because those who have survived rape, be it men or women, whatever woman is an adult or a child, those survivors have to go through a long procedure. Rape is usually and often committed in a closed place, and rape is a problem where often evidence disappears, but evidence continues to be alive. And it cannot be kept a secret for a long time. This has led to a long discussion where Senegal wanted to criminalize rape. You know that it's just an offense in Senegal. And we can have sentence with 10 years when it's a minor, less than 13 years old that has been the victim, or if rape is followed by the death or by assassination, which is up to 20 years of imprisonment. And others think that to criminalize this, is that a solution with regard to the survivor of the offense? The survivor, is the person interested in criminalization? Is the survivor interested in a death sentence? No. They want to be rendered justice. Whatever the adult or child wants that justice is done. Justice is important for mental health, for psychological reasons, for reasons regarding their economic situations. The victim of rape is that you're not assisted by the state. So the perpetrators need to be put in front of a court. So criminalize it. And once in front of the court, we see that justice is rendered. So 5 lawyers supporting the perpetrator, and often the victim is not represented by any lawyer. The victim is alone in front of the judge. That's often the case. Imagine the situation. You are the victim, a minor. Recently, I had a dossier at the Cour d'appel, second level of jurisdiction, and the child was accompanied by the parents. The perpetrator was the uncle. So that's the fact. Well, who is the perpetrator? You've got a child fast in view of its uncle. And it was so shocking to see this, because a child in front of its uncle, who is supposed to be the perpetrator, that is something that was shocking for as a judge, and see that there's no support. So I asked the judge, I asked the court to put the child to the side, because it was too difficult for it, too many psychological obstacles. And once set the obstacles apart, there are also cultural and social barriers that are important. We find ourselves in Africa. You know, if you are a victim of rape, you are sort of put to the side, pushed out of your circles. You won't find a husband, because there are others that... But there are many that don't want you. You need to be virgin. So you are marginalized by your family. Even a marriage has to be dissolved, or you won't find any husband, because you have been a victim of rape. But the lady could not tell her husband this. The son was 15 years old. And then she came towards me and said, Madame le Juge, please help me, because I cannot go on living with that man. Why? Because I was a victim of a rape. And then I asked her, do you have to speak about that with your husband? So rape is killing you psychologically. Cultural and social-cultural barriers do continue to exist. They are obstacles to going to report a crime and go to take go to a court, and so that justice can be rendered. So we have the penal code. It's written in a foreign language, in a language which is different from our local languages, not understandable. And at least you need an opportunity so that women can understand the legal procedures. The lack of legal advice, of legal support, can hinder women from going to courts and report crimes. But another fact, if you permit, the psychological support is also very important. I've already said that this psychological support is essential. Once we have obtained the criminalization of rape in Senegal, we have been appreciated that and been very happy, because generally speaking, rape are hateful offenses. They degrade the person. But when it comes to the perpetrators, the authors of this violation of law, they still have a problem, but the victim is really suffering from that crime. So we need not only legal support, but also psychological support, so that it's possible to take a lawyer if you're subject to rape, and you need also psychological help. But for minors, it's even more difficult. There's a special court for children. And you cannot put a child into prison if it has been a perpetrator. No. And I say, but whatever the gravity of violation of law is, they are responsible. There is a certain level of responsibility. And in Senegal, we say that this is the system that is responsible. So what we try to achieve is to reinsert the child into society, not to put it into prison, not to have a punishment which is too harsh, but harsh punishment for adults, but for children, we need to provide help, assistance. They cannot be kept in a place where we have no adults. They need to receive support. It's the dignity of the child that also needs to be respected. As for adults, even if one has committed an offense, the dignity of the offender always has to be respected. So we should limit ourselves to sanctioning the offenses, but not violate dignity. Dignity is a sacred thing and needs to be respected. There are always alternatives, and Senegal looks for having alternative punishments instead of the capital punishment. Thank you.
Thank you so much. And I want to reiterate, I really resonate with what you said about the responsibility of the society, right? When we decide that these are people who are subhumans, they are demons, and we should just get rid of them, the society is completely absolving themselves of any responsibility for a culture that we create where rape happens. And somehow we take it seriously only when we see bodies of victims being violated, when they've been brutally raped, there is injury, but we somehow close our eyes and completely normalize the day-to-day sexual harassment that happens. And one has to understand that sexual violence is a spectrum. And I think as a culture, we need to be more intolerant about what we think are not very serious instances of sexual violence, sexual harassment, and how there is a complete disconnect in how we react as a society on this scale of spectrum. I'm going to skip a few questions for some of you because Ariane has given me that look and we're running out of time. So Zaman, I want to move to you quickly because you authored this report specifically on South Asia and sexual violence. I want you to sort of quickly summarize for us what did the experts make of the suggestion that death penalty is effective in addressing the needs of the survivors. A very quick summary. Thank you.
Thank you very much. And thanks to ECPM and everybody else who worked hard for having us here. One small correction is I co-authored, not I authored it alone. So two other authors, Professor Sarah Cowell and Mai Sato, they worked together with me as the author. But I happen to be the consultant for the research. So it's quite a thick report. You can get it online from Monash University Elias Justice website. Very precisely, I will be in very quick and bold point. Maybe later anyone has questions, we can respond if time permits. So the experts on two major aspects. First of all, regarding this point, the question that Nitika asked is one, socio-cultural behavioral pattern. They made their assessments and observations out of the experiences. And the second part that they also talked about, the criminal justice institutions, systemic dysfunctional feature in addressing the issues involving rape and other sexual abuses. So from the first one, the socio-cultural behavior that already the experts on the stage, they have said some of that. Very briefly is the acquaintance of the survivor and the perpetrator within the family or neighborhood or the relations. And then there are might be teachers saying in some cases in the case where the children are victims. Then the individual survivors, they also have to rely on the decisions of the family and mostly dominated by the men to make the decision whether the case has to be reported to the police or not. So the survivor herself, the victim herself, cannot decide about the crime and registering the crime. So that, and they, you know, in South Asia, there's a patriarchic culture, so the power inequality between men and women. So that also contributes to the process of seeking justice or or even talking about the problem itself when it happens. Then there is a self-contradictory position of the society. I'm trying to be very quick. One is the women being treated as like embodiment of honor of the family, and at the same time, there is a misogynistic victim-blaming culture in the society at the same time. So it's against each other. Preventing the women and also the family from seeking justice when the acquaintance, perpetrator is also known. So in one hand, your honor is being affected, and then the person or the woman, the society thinks that they are the embodiment of their family honor. At the same time, they prevent the process of justice in many instances. And the expert also observed that this kind of pervasiveness and the culture and the silence that perpetuates the cycle of impunity within the society itself. So that's one part. Next, the criminal justice institution aspect. There is a survivor-unfriendly handling of rape cases in the entire South Asian jurisdictions. We are talking about altogether 4 countries that were part of the research, but Sri Lanka doesn't have directly death penalty for rape unless firearms are used. So I'm excluding that from that. So here, Bangladesh, India, and Pakistan, these are 3 countries mostly which are very active. And very recently developed laws to punish rape with death penalty. Rape, gang rape, and that leading to death of the victim. So these 3 particular countries, and this one of the problems with the policing system in all these jurisdictions is that the police very proactively dissuade the victims or the families not to register the complaints. So, and that is quite frustrating for the experts. Then there are 3 primary areas also of concern that the experts have pointed. One is the reluctance of the police, then the insensitivity of the entire professionals, the criminal justice professionals. These countries, in different names, they have some one-stop crisis management center. So India, Bangladesh, Pakistan, both have with just similar or different type of names, but the job is same. But these institutions, it doesn't function as a survivor-friendly or the litigant-friendly, if we also include the perpetrator in that. So it's you cannot expect professionalism from them. The other part is the inadequacy in terms of police investigation, in terms of medical legal examination, the forensic examination system. So everything is by name, it's there, but in reality, it's not there to support the process of addressing the crime. And of course, the inadequate resourcing to the entire judicial systemic, the institutional infrastructure is unbelievably low. And that prevents people from seeking redress from the systems itself. And there are some very objectionable behavior of the institutions is that something very primitive called 2-finger tests. So that is prohibited by the judiciaries of the countries mostly, but it's still in practice. So you see how the functionality and the assertiveness of the institutions itself. And I'm not going to repeat some of these things that already. One of the things is like, in Bangladesh, for example, the judiciary sometimes plays the role of a matrimonial agency. Judge orders the perpetrator should be married to the victim. And sometimes also the police and the investigator, they insist the victim to compromise with the perpetrator of rape. So, and there are instances of other countries in the region that settlement outside the court and the situation of victims not being able to hire a private lawyer because the prosecutors are not well equipped. They are always not the professionally well-trained prosecutors. So then if you want to, establish your case seriously, and if you are from underprivileged, financially at least, then you have very less chance. Judge, in your keynote speech, you have also mentioned that. But in South Asia, this is very common and very disproportionately common. And the research, the experts have shared this experience. So I think the time is giving a signal. Okay, let me just, if I'm missing anything, and yeah, so the access to lawyer is a very serious problem. One of the thing is the conviction rate. In South Asia, it begins with highest in India, I think it's 39% altogether, right? 32, okay. And from Bangladesh, it's 2%. So you can, between 2%, 4%, that's the conviction rate for rape cases. So that's very highly frustrating. So I will stop there. If we have time to, respond to questions, I'll take that opportunity. Thank you.
Thanks, Aman. Thanks for doing that so quickly. I understand that we're eating into the Q&A time, but I'm going to take 2 more minutes just to ask final questions to both you, Valerie, and Bharti, because both of you directly work with survivors in a jurisdiction that is using the death penalty for sexual violence. And what I want to ask the two of you is, because this is the World Congress Against the Death Penalty, what I want to ask is, what are some of the common grounds that you identify in your countries for child rights, women's rights, and people who work against harsher sentences to come together? Would you like to start, Valerie? And if you could just take a minute, and then we'll move to you, Bharti. Thank you.
I would say it's very useful, and certainly it adds legitimacy to your anti-death penalty argument when you are bringing child protection, more than women's rights, but child protection activists, because we're supposed to really look after children and be the good people. And then when suddenly we're telling them death penalty is a terrible idea, if you really want to help children and actually counter sexual violence, which I just like to emphasize that it's certainly not limited to rape. So we actually bring that legitimacy, and we are being more pragmatic. You know, the human rights narrative with death penalty is a violation of the fundamental human dignity is clear, but we also are saying, because most of the perpetrators are known to the child, you're actually promoting the rule of silence and not child protection. Because your investigation and prosecution process is so imperfect, you're actually promoting denial of justice and not justice. Because you're not focusing on early child protection, on reformative justice, you're actually preparing an entire generation of potential criminals or victims, and you are therefore contributing to perpetuating this intergenerational cycle of GBV and sexual violence or other form of criminality. And then we come up saying, how do you become a sexual offender? What makes you become one? And that's where the overall systemic failure to protect children, to build up healthy boundaries, to promote gender equality, to get away with harmful practices, to focus on mental health, monitoring processes, rehabilitation processes. So suddenly this is a much bigger horizon. That's where also forensic mental health comes in. But it is something which is, at least in the context of Pakistan, increasingly finding an echo. I think at the regional and international level, it's also the case. It's just that we have a tremendous amount of work ahead. And I think that with all of you, hopefully we'll be the tiny, tiny part of the process to reach there.
Thanks, Val. Bharti, in addition to what Valerie has spoken about, would you like to add a few things from your experience?
Yeah, so I would just like to basically say that we need to certainly lay a lot more emphasis on restorative care and rehabilitation aspect, to which very little attention is being paid. And the other aspect, which is where you began, Nitika, that we can't have all answers in law. And therefore, we need to start working with communities on the issue of sexual violence. Having said that, I'll also come to some questions of, for instance, the age of consent, which is such a big problem today in India because, again, as Valerie said, as child protection activists, we all want children under 18 to be protected. But we then get into a very protectionist approach and end up criminalizing children. So how can criminalizing adolescents actually lead to their protection is a question to ask. So we need to do something about age of consent and probably go back to where we were earlier, which was 16 in the Indian Penal Code, with 25% cases in the trial court system being cases of romantic relationships. And it's worse when the relationships are interfaith and intercaste. And that's when, in most cases of romantic relationships, girls do turn hostile and the cases end in acquittals. But when it's interfaith, it's worse because there's so much pressure on the girls that they do not turn hostile, and the sentence can be death penalty now if there is repeated sexual activity between them. So we really need to do something about that. And we need to talk about balancing of rights, harmonious construction of rights, which is not happening at the moment. So we go to extremes. So one court which says you marry the perpetrator, another court which says death penalty. The extremes have to be really balanced out. I think everyone from the women's rights movement, from the child rights movement, and also from the LGBTQI movements, we've considerably been worried about these extreme situations. So that's where I leave.
Thanks, Bharti. I think we have about 20 minutes for Q&A, almost 20 minutes. So yeah, we'll just hand over to you guys. I see someone on my left.
Hi, my name is Samir Nouri from Iraq. Actually, in Iraq, the sexual violence is very high. I indicate to the 3 cases. One of them is ISIS raped more than 5,000 Yazidis. I think the world know that. They sell the women, they rape them. Still, there is a lot of them under the control of ISIS. That's one. The second one, about the LGBT community, gays and lesbian, trans. And in Baghdad, they killed more than 100 young guys, they say that's emo, by the piece of concrete on the streets. That's the second. Third one, I think depend on the Sharia law, the most of the marriage is depending on the rape. How come? The young girl on 30 years or 12 years, when they go to the marriage, this is raping the kids. In my country, in Iraq, I know in Iran, in all the Middle East, this has happened. And I have a case one woman has been sentenced to death because of the marriage. She was young girl, 13 years. After 15 years, conflict with her husband, she killed her husband. So now sentenced to death. A lot of women facing those problems. Just I want to raise the problem because there are no more times. Thank you.
Thank you for sharing that. Just one logistical thing. if you could just tell us in the beginning what your name is, whether you're going to be asking a question or making a comment, and if it's a question, if you could mention the speaker that it's directed to. Thank you.
Très bien. Je me présente, je suis Nouzha Sqali.
I'm Shouza Skali, Minister for Children's and Women's Rights and coordinator of the network of members of parliament against death penalty in Morocco. When it comes to death penalty, Morocco has made a lot of progress thanks to the social engagement and civil society and members of parliament that are against death penalty. But when you've got rape crimes and crime against children, it's public opinion that is in favor, more and more in favor, normally of abolition of capital punishment, but then they claim the application of the capital punishment because the crime is so horrible. And then it's easier to claim capital death than the liberation of sexuality. Sexuality is a taboo in Morocco, as in many other countries where there is an ideology that is very conservative, or I wouldn't say Islamic, because there are other religions where with similar conservative opinions. Then it's young people that are encouraged to take up sexual relationships to show their masculinity, but for women this is prohibited. So that's a situation which leads easily to sexual aggression and sexual problems. And as you said in your intervention, this is mainly women that feel guilty. So they are transformed into guilty persons because they are sort of abused. They come out of this sexual harassment in a difficult situation. Only 3% of these persons that are subject to rape or sexual harassment go to the police and report it. That means that the aggressors remain unpunished. So I'm very happy that the question of legality of women has been given some focus here, because it helps to reduce rape and to ask for the death penalty, which will not solve the problem, neither for sexual harassment towards women, nor for problems with children or sexual harassment with children. So this is important, because there are also men that have been subject of sexual harassment and violence when they were children. So thank you very much for all the interesting and very valuable contributions that we've heard from all of you.
Thank you so much for your comment. I'm just quickly going to arbitrarily use my discretion as the moderator and ask Shokri something that I wanted to ask earlier, since you raised the point about public opinion. Shokri, there's a social media campaign calling for the death penalty in Tunisia. There was rape and murder of a 30-year-old woman, Rehma Lehmer, and now the public is sort of wanting the death penalty back for sexual offenses. And I wanted to sort of get a sense of what do you make of these public demands, and how do we educate the public more, because at least the context that I'm familiar with, which is South Asia, what you see is that narrow 1 or 2% cases that are used politically to move towards harsher sentences, but the 99% cases are what the public is unaware about, which is why it is easy for them to ask for the death penalty. So how should we deal with this question of death penalty? Is awareness of the public the solution? How would you respond to that? Thank you.
Yes, in Tunisia we have a moratorium since 1991. It's a moratorium de fait, not de jure. So to ask for public debate is important, but the authorities until now have always negatively responded to that requirement. But it's episodically when there is a hateful crime or a terrorist attack that all of a sudden they ask, the society asks for putting the death penalty again into action. And this is just a one-way road. So there is one factor. This recent campaign, which consists in asking the re-establishment of capital punishment, starts it by the President of the Republic, elected in 2019, who said that he wanted to re-establish the death penalty as a divine and sacred punishment that guarantees justice and dissuasion. So then different organizations said that this is not really something that is in the interest of women. If it's the president of the country that asks for that capital punishment, but at the same time he is against equality of women, then this is a contradiction in itself, because he thinks that women are only half of men, so we cannot really say that he is a champion in defending victims, female victims, and at the same time he doesn't see them equal with men. This is already a contradiction, so we now have to denounce and we have to condemn this, and we have to... would like to quote a Belgian philosopher, Chantal Mouffe, who calls him the populist moment. So it's an expression, a local expression of a populist moment in Tunisia. And this is an instrumentalization on the political level of crimes and of sexual violence, just to try and reestablish the capital punishment. This is against civil society. And in the media, in the social media, social networks, they describe that as a vision anti-elite, anti-modernity, anti-acquis, and against the modernist realization of Tunisia. So it's a process in Tunisia, a historic and legal process that goes towards recognition of women's rights, that has criminalized crime of rape, that does not give the perpetrator right, because in the past it was different. The responsible person of rape could sort of balance out all violence against women by marrying her. So this is important to know. We have ratified in 1985 the Copenhagen Convention CEDAW. There are other important regulations that we comply with. For example, the 2018 Maputo Protocol regarding the rights of women in Africa, the promulgation of a law in 2017 where physical, moral, sexual, economic and political violence against women should be eliminated. So that's a progress that is immense in this struggle against violence and discrimination, and we cannot now ask for capital punishment. Instead, we should replace it by life imprisonment. So the President of the Republic now demands that capital punishment should be reinstated, and this is done in the framework of a populist project that does not take into account rightfulness, legality, just born by a conservative ideology which is reactionist, which is looking backwards, which is sexist, and which is against universal rights. So we have to defend the universality of human rights, that we need to defend against what Nobel particularism, cultural and elsewhere, and this goes back to the Sharia, the Islamic law, and a re-Islamization of the country. And it is not in line with our neoliberalist ideas. So we struggle for the equal rights of women, the right to life, the abolishment of death penalty, dignity of men and women in Tunisia. They need to be respected equally, and we need to restore that. Thank you very much.
Thank you, Shokri. Before I move on to the next question, I just wanted to say that I resonate with a lot what Shokri said, but I just wanted to disagree on one aspect, and it's a conversation for another time. But I think that we need to also be critical about life imprisonment as a sentence for sexual violence, because a lot of the critique around the death penalty for sexual violence and completely closing the possibility of reform for an offender equally applies to life sentence. And we see that across the world, with the movement away from the death penalty, life imprisonment without parole, without remission is emerging to be the harshest sentence. And I think we need to adopt a critical approach towards that as well, so that in our move towards abolishing the death penalty, we don't end up legitimizing the space for life imprisonment. So I just wanted to sort of state that out. Yes, sir.
My name is Bhupinder Singh Gill. I am from Chandigarh, India, and I represent advocates for human rights. One typical situation has arisen, perhaps in our country or some other countries also. The victims of the rapes are being killed by the perpetrators. And because the reason being that evidence should not be there for their punishment. So this question is very, very important to be considered. And there are so many cases after both Nirbhaya case in New Delhi, in India, this system has developed. There are so many cases, dozens of cases, when the women and children have been killed after the rapes, only because that no evidence should be there. The other point is of marital rapes. Marital rape is such a sensitive issue. Even judiciary is very much confused on this issue. Different judgments from the honorable judges are coming. Some says marital rape, no problem. It's their only issue. But marital rape is a very sensitive issue. Consensus must be there. If woman has not given the consent, even the married man should not go for the sexual things with that. So this is my question, which may be considered by the panelists. Thank you very much.
Thank you. Since it sounded more like a comment, I will just quickly respond to it. And thank you for saying that. I think that's been one of the fears of the child rights movement and the women's rights movement, that when you introduce the death penalty for non-homicidal rape, you are encouraging the perpetrator to kill the victim. And while there is no empirical evidence as of now to show that correlation, but that is very much a fear that has been vocalized. Our crime in India, the NCRB crime statistics has started making a note of these cases, but I guess we'll have to just wait for some time to see if there is any impact. But that's a very, very important comment. Thank you so much.
I'm Rayam Rash. I'm from a movement in Paris, in France. I have a question for Bharti Ali. I think it's very interesting that you said there is a difference between the sexes when it comes to rape. whether it's girls or boys who are raped. Are there any answers? Why have you less severe sentences, whether it's a girl or a boy who is raped? Thank you.
No, in terms of sentencing, there is no differentiation whether it's a girl or boy or a transgender child who is sexually assaulted. There's no difference in sentence. The difference lies in the way justice is meted out to the different to children of different genders. Male child sexual abuse is not something that is readily acceptable in many societies, including India. Because a lot of boys don't come forward and report. It's a question of masculinity that must be maintained. And B, even parents don't want to report because then they feel, I mean, the first question that comes to a parent's mind is that, will he be able to have normal sexual relationships when he grows older? Can he have a good married life? You know, those are the questions that come to their minds. So male child sexual abuse is definitely not something which people are ready to talk about more openly. And when it comes to doctors also, we have realized that as far as medical examination of girls who are raped, we've got guidelines, we've got protocols, there is a way to go about it. But when it comes to male child sexual abuse, we don't have guidelines and protocols. And so doctors are also really struggling as to how to conduct medical examination. So it starts from families, from communities, goes up to professionals like doctors, and then, of course, judges who are not ready to understand male child sexual abuse.
Yes, please, go ahead.
The nuance is also really about what constitutes the taboo related to homosexuality and child abuse. And it's not always easy or clear enough to demonstrate how a child victim is actually a victim, regardless of the sexual, the nature of the sexual offense that has been committed, which may correspond to what in certain societies you define as homosexuality. So the boy victim, I think in Pakistan it has now been clarified, but from a socio-cultural perspective, a boy victim is likely to be considered a homosexual before being considered a victim of sexual violence, and therefore it's not easy to, how should I put it, to try in a child-sensitive manner, and there are higher risk of secondary victimization and secondary trauma for such victims, basically.
Thank you, Val. I'm sorry we've run out of time, but we can have a conversation in the break. Thank you so much to the speakers for a very, very insightful conversation. I really enjoyed it. I hope all of you enjoyed it too. And I hope that this conversation leaves you with more questions about what is the role of punishment when we think about sexual violence. And I want to just end with this, that we are not saying, or we are not disregarding the fact that individual survivors or victims of sexual violence may not see death penalty as justice for them. But the conversation today has basically been to demonstrate that the idea of justice is not homogeneous. In fact, it is very, very heterogeneous, and it can mean different things for different victims. So the problem is when the state co-opts a very homogeneous idea of retributive justice and offers it as the only form of legitimate justice. And I do hope that we will reflect more about these about these questions, and we're happy to talk if there are any more questions in the break. Thank you so much.